This week, there are 2 recorded lectures for you to view, and they cover Chapter 2. We're skipping Chapter 1 until the end of the semester. Here's the 2 reasons why. First, as I mentioned in the live Zoom session, our textbook is really a book attorneys use in the everyday practice of law. Chapter 1 covers almost exclusively things helpful to an attorney and not so much for paralegals. The book assumes a lot of key words and terms we're going to learn, but would already be known by an attorney. However, you still need to learn them. So as we go through the chapters, that's one of the main reasons and one of the main things we're going to be doing this semester is increasing your legal vocabulary. Therefore, Chapter 1 will be more meaningful to you after you've learned the legal words and terms we're going to cover this semester. Hopefully, then Chapter 1 will make more sense and tie things together better for you. Second reason, I want to get right into the material with which a paralegal would work. Stuff paralegals need to know, whereas Chapter 1 is more things that are nice for a paralegal to know, but not as critical. For those reasons, we'll come back to Chapter 1 at the end of the semester. Before we get to Chapter 2, 2 introductory comments. First comment. The title of our course is Introduction to California Civil Procedure, and the title of our text is Civil Procedure Before Trial. The text title is not truly accurate. The text should be called California Civil Procedure Before Trial. That's the subject matter of the textbook, California law. Other than very briefly, I'm not going to get very much into the federal court system, just California courts. In other paralegal courses, you've already learned or will learn there is a California court system and a federal court system. The distinctions between these 2 systems are not what we cover in this class. As such, unless I should mention differently, the procedure we're going to learn this semester is for California, the California court system, not federal. Should you get a job where the litigation occurs in the federal court system, while there are many, many differences, your understanding of California procedure will give you a strong base for understanding federal procedure. Here's a tip for you. Although our textbook is California procedure, you're going to get used to this textbook. And when you get a federal case, the publisher of our textbook, the Rudder Group, also has a federal civil procedure treatise as well, in the form of a 3-ring binder. If your office does federal work, there's a good chance they will have that set of books. As I just mentioned, I'm not going to get into detail as to the differences in processing a lawsuit in California state court system versus the federal court system. I'm also not going to discuss how a case proceeds after the trial court level to the Court of Appeal or to the Supreme Court. Unless I mention otherwise, everything we're going to be talking about this semester is at the California trial court level on your screen in the green color. The California trial court is called the Superior Court. In Superior Court, there is 1 judge and often a jury, but not all the time. At the higher court levels, that would be the Courts of Appeal or the Supreme Court, there are justices. At the Courts of Appeal, 3 justices. California Supreme Court, 7 justices. There are no juries at either appellate level. But for the most part, we're going to be sticking to the trial court level in California, the Superior Court. In your mind, you could put a big X through the federal court system. We're not going to be talking much about that. and you could put an X through the first appellate level and final appellate level in the California system. The second comment I have before we actually get into Chapter 2 are a few legal terms you must know, and I want to make sure we're on the same page. Let's look at the parties to litigation at the California trial court level. That's the Superior Court. If you didn't know this before, you need to know this starting this semester. The plaintiff or the petitioner. The plaintiff or the petitioner is the party that files or commences the lawsuit. Many times, lawyers abbreviate plaintiff as PF, or they use the Greek symbol for P, the pi. The party that defends or responds to litigation is the defendant or the respondent. Many attorneys abbreviate defendant as capital D, capital F, or use the Greek symbol for D, delta, the triangle, as you see on your screen. In certain instances, a cross complaint gets filed, and the party that files the cross complaint is called the cross complainant, or as lawyers sometimes use, X-PF or X-pi, as you see on the screen. The cross complainant files a new action in an already existing litigation. And then when the cross complainant files this new action in the already existing litigation, there's a party that defends or responds to this new action, and that party is called the cross defendant, or as lawyers sometimes abbreviate it, X-DF or X-delta. Now, for the most part, we're not going to be using the terms petitioner or respondent. Those terms are usually used in family law matters, but we're sticking to civil law in this particular course. Also, for the sake of simplicity, I'm usually not going to be using the term cross-complainant or cross-defendant. For the most part, everything I say about a plaintiff is identical for a cross-complainant. And everything I say for a defendant is identical to a cross-defendant. So for that reason, I'm just going to, for convenience, stick mostly to using the term plaintiff and defendant. Now, you don't need to know this for any exam, but in federal court, some of these terms are different. For example, and you see there with the asterisk, we don't use the term cross-complainant in federal actions. Why? Because in federal court, we don't have cross complaints, we have cross claims. Anyway, don't worry about it. One of these days, when you get into a law office and you start using federal terminology, you'll simply know that there are different terms available. All right, now we're finally getting into the outline and the minimum reading requirements that I posted on Canvas, and we are now to Chapter 2. Can anyone be a party to a lawsuit? Here's the hypothetical. Thelma is driving alone in her car, and she's going to go see her good friend, Louise. Brad runs a red light and collides with Thelma. Thelma sues Brad because she wants money to reimburse her for her medical bills, damage to her car, lost wages, and for her pain and suffering. Louise has a great idea. Louise says to Thelma, I'm going to sue Brad too, and get me some money, and then we can both run off and party. Hopefully you figured out from reading the material or from just plain common logic. Thelma has a good lawsuit. She was hurt in the accident, but Louise does not. Now, that was obviously a crazy example, and it's too bad this chapter is just not that simple. But what we need to discuss is standing to sue, and that's our very first section of chapter 1. In the example I gave you, the only real party in interest is Thelma. Louise can't join in the lawsuit or file her own lawsuit because she is not what is called a real party in interest. Who or what is a real party in interest, sometimes referred to as an RPI? It is the person who or the entity that suffered the loss or injury. That is the person who or the entity that has the right to seek relief from the court. It is often referred to as being personally aggrieved or having a stake in the legal outcome. When Thelma had the accident, Louise did not sustain medical bills. Louise did not sustain property damage. She sustained no loss of earnings or even physical injury. Therefore, Louise is not a real party in interest. But Thelma incurred medical bills, property damage, loss of earnings, and physical injury. Therefore, Thelma is a real party in interest. The key is whether the plaintiff lost something, whether it be money, property, or health. If so, then that person is a real party in interest. The key legal terminology is whether the person has standing to sue. A real party in interest has standing. Now, I want to discuss a California exception to the rule of standing, and it is something of which you should be aware. The California Supreme Court, in a landmark decision entitled Dillon, D-I-L-L-O-N versus Legg, L-E-G-G, established the right to make a claim for negligent infliction of emotional distress. This is where they expanded the concept of the real party in interest. Let me give you a real life example of a case I handled a number of years ago. A sister and her brother, the girl was, I believe, 12 years old, and her brother was 8 years old, got back from school. They were on a field trip. The field trip ended late, and the crossing guard near a major street had already left for the day. When the children started on their way home, the boy ran out into the street ahead of his sister, was struck by a car, and tragically killed. His sister was but a few feet behind him and observed this. Now understand, the sister was not struck by a car. The sister did not suffer any physical injuries. Yes, she did suffer mental injuries, obviously. And that is why Dillon versus Legg has come about. So the little girl was able to make a recovery even though she was not the real party in interest. Now understand, this exception to the rule of standing is that the non-physically injured party still must be a close relative of the injured party and has to be what is called within the zone of danger, or in other words, witness the horrific accident or injury. In other words, the child's mother, who was not present at the time of the child's death, cannot make a personal injury claim. She is not a real party in interest. Now, the mother does have a separate claim for wrongful death, but that's a different argument and that's a different cause of action. By the way, not only do people have standing, but so do corporations, limited liability companies, and other entities. General Motors and Ford have standing and can sue a supplier that delivers faulty parts. If GM or Ford sustain a loss, they are a real party in interest. And even if a person dies in a traffic collision, a representative of the defendant of the decedent's estate has standing and can sue. The decedent's spouse or children suffered a loss, and that is called a wrongful death. Section 3 of this chapter discusses something called fictitious businesses. Probably the major real party and interest exception is those who do business under a fictitious name. For example, Betty owns a beauty parlor called House of Elegance. Betty does not want the expense of being incorporated, but she wants to do business under the name of House of Elegance. Legally, House of Elegance is not a legal entity and cannot be a real party in interest. It is not a corporation, neither is a limited liability company. When Betty does her income tax return, she completes a regular Form 1040, just like anyone who receives a salary. But if Betty registers her fictitious business name, House of Elegance, with a county in California, now that business can be a real party of interest in a lawsuit. For example, House of Elegance purchases equipment for the beauty shop, but the equipment doesn't work properly. The supplier refuses to give the money back, but now House of Elegance can sue the supplier because there is a fictitious business name statement on file. An individual, a corporation, or other business entity can operate under a fictitious business name. What you see on the screen is the type of document a paralegal would prepare in a law office. The paralegal fills out this one-page form, records it in the county where the person or business is doing business, publishes the fictitious name in a newspaper one time a week for 4 weeks, and now this entity has the right to sue or be sued. For your information, on the screen is a Kern County example of a fictitious business name statement. I did this because Los Angeles makes it very difficult to print an example. Every county has its own form, but they are all very similar. Let's go back to my original example. Louise sues Brad for the accident in which Thelma was injured. Louise happens to get a judgment for $10,000 against Brad. Now Thelma, who was injured, gets around to suing Brad for her injuries and loss. In California, Thelma has up to 2 years to file her lawsuit. Brad will defend Thelma's lawsuit by claiming he already paid for the accident, which means Thelma gets nothing. That is why in law, only the real party in interest has the right to sue. And that is what section 4 in our chapter is about. Only the real party in interest has standing. Now there are some other exceptions. I told you about one, Dillon versus Legg, but there's 3 others that are referenced in our book, starting at section 40. Parents suing for injury to a child. We're going to soon learn minors can't file lawsuits. But what if a minor is injured? It is the minor who suffered the loss or is the aggrieved person. The exception is a parent can sue on behalf of and for the benefit of the child, even though the parent was not the injured party. Another exception, what's called in our book representative suits, or what is more commonly known as class actions. This is where one or a few people sue on behalf of a larger group of people. Example, a few years ago, a number of people sued Carnival Cruise Lines for misrepresenting prices. Carnival was advertising on TV something like 3-day cruises from LA for $99. The problem is that once all of the taxes, port fees, and other things were added in, the $99 cruise was actually around $300. This class action lawsuit settled, and the agreement was that Carnival had to issue everyone who had taken such a cruise over the last 3 or 5 years, I can't remember the time period, a $100 voucher good toward their next cruise. You say, who cares? A certificate for a small amount of money toward another cruise? Well, this is the real world, and I guarantee you the lawyers who filed the lawsuit cared because they received several $1,000,000 from Carnival as part of the settlement. And if you think, damn lawyers, remember, those lawyers are the ones paying your salary. Third exception, county suing for child support. This is at section 71 in the book. Let me give you an example. Child has been abandoned by the child's parents and picked up as a runaway. Because the parents may be irresponsible or even abusive, the county will place the child in a foster home, and the county has to pay money to the foster parents to care for the child. Under California law, a child has the right to have his or her parents support him or her until the age of 18. So the child is the real party in interest. They're the aggrieved party. They're not being supported. But the county can step in and sue the parents in the child's name to obtain reimbursement to the county for what the county is paying the foster parents for taking care of the child. Our book next goes into at section 77, the procedures for challenging a plaintiff's lack of standing. Before the party has to file an answer to the lawsuit, the party can go to court and argue the person who actually filed the lawsuit is without standing, and the lawsuit should be dismissed right now. This can be done by the defendant filing what is called a demurrer. We're going to get much deeper into demurrers when we get to chapter 7. But for now, think of a demurrer as where a defendant who must defend a lawsuit goes to court and says, I shouldn't be required to do anything because there's a problem with plaintiff's lawsuit. One such ground for a demurrer is the party who brought the lawsuit has no standing to file it. Back to our example. Louise sues Brad because of his traffic accident that injured Thelma. In real life, what Brad would do is file a demurrer to Louise's lawsuit, and the basis for the demurrer is that Louise has no standing because she wasn't the one injured or aggrieved. But assuming Brad doesn't demur, and Louise does get a judgment against him for $10,000, now Thelma can come to court and still object to Louise's standing and get Louise's judgment thrown out of court so that Thelma can proceed forward with her own lawsuit against Brad. This concept of what happens if nobody objects or files such a demurrer is discussed at section 78. Standing is such a fundamental concept that the failure to object to standing can be raised at a later date, even after a judgment has been rendered. The law is as follows. Standing can never be waived. You always have the right to object to standing. Keep that in mind when we get to our next topic, capacity to sue. We're to sections 80 and 81. We just looked at standing to sue, which is the right to seek relief from the court. Who can get relief? The aggrieved party, the plaintiff who has a stake in the outcome. We're now turning to capacity to sue or to defend. Capacity is the authority to come to court, either to sue or defend an action. What are the main differences between standing and capacity? First, if a person does not have standing to sue, the other party can raise that objection even after the trial. But if the person's capacity to come to court is not challenged on a timely basis, then that challenge is waived. Second difference, challenging one's standing is always where the defendant attacks the plaintiff's right to bring a lawsuit. Challenging one's capacity attacks a person's right to bring a lawsuit or to defend a lawsuit. In other words, either plaintiff or defendant can challenge capacity. Let me give you an example. A 17-year-old is struck by a car walking in a crosswalk. The 17-year-old has standing, personally aggrieved, he was injured, but lacks capacity to sue. By law, minors have no legal authority to come to court. But if the 17-year-old got a judgment and defendant didn't challenge capacity, the judgment is still good. Now we're going to move into the application of capacity and look at it in 5 situations where capacity can be challenged. Or in other words, where a party can say, you don't have a right to file this lawsuit, or could say, you don't have a right to even come to court and defend the lawsuit. The first category, minors. Simply put, people who are legally minors lack capacity to sue or be sued unless the minor has been emancipated, which means the court has adjudicated the minor is now an adult. A non-emancipated minor, and that's the vast majority of people in California under the age of 18, do not have capacity. However, a minor can sue or can be sued through what is known as a guardian ad litem. And usually the guardian is the parent of the child. Regarding a minor, let's turn to what needs to be filed when the minor has standing. In other words, the minor has been injured and needs to file a lawsuit but lacks capacity. What needs to be filed is called an application and order for appointment of guardian ad litem. What you see on the screen is the form CIV 010. You can see it at the red arrows, and this is often prepared by paralegals. The guardian ad litem petition is on the screen, and I provided a copy for you on Canvas. First, this is a judicial council form. It can be filed in all 58 counties in California. It's form CIV-010. Note who is the plaintiff, and that's at the blue arrow. Billy Perez, a minor. Wait a second, minors don't have capacity, but it says by and through his guardian ad litem, Pauline Perez. I also want to call your attention to another term, which is circled, called ex parte. Ex parte is Latin for without notice. In connection with an application for appointment of a guardian ad litem, the defendant does not have to be noticed of this process. The petitioner simply files the document with the court, assuming everything is in order, the document is signed, and then the petitioner can move forward with the lawsuit on behalf of the minor. Let me walk you through this form. Item number 1 on the left screen, applicant Pauline Perez is the parent of Billy Perez. Number 2, information about who is the applicant, her name, address, and phone number. Item number 3, who is the minor? And by the way, this form can be used for anyone who is incompetent. For example, an adult who has dementia, if they're injured in an accident, you can file an application to have somebody represent them in court. Note that item number 4, we checked off the box as a minor. If there was an adult who was an incompetent person, well, you would check B. Then item 5, the court should appoint a guardian ad litem because the person named in item 3 has a cause or causes of action on which a lawsuit should be brought. Why? Because while riding his bike, Billy Perez was struck by a truck owned or operated by defendants. To the right side, number 5. Now we've got to state why an appointment of a guardian is required. Why does Billy need to have a guardian? Well, there's box D. The appointment of a guardian ad litem is necessary for the following reasons. As Billy Perez is a minor, he lacks capacity to bring an action for his injuries. See, he has standing, but he lacks capacity. Item number 6, they want to know who the proposed guardian is. Usually it's a related person. The lawyer signs, the guardian signs, and then at the very bottom of the form, you see the word order and then a box that says ex parte. And you can read there what I've typed in. The court orders that Pauline Perez is hereby appointed as the guardian ad litem for Billy Perez for the reasons set forth in item 5 of the application. Billy has standing, but Billy doesn't have capacity. Once this form gets filed with the court, then the mother, or in this case the guardian, can go forward with the lawsuit. Very typical form for a paralegal to file in any office that does personal injury work. Next category, corporations. Corporations can have capacity to sue or be sued. Simply put, corporations have the right to sue. Corporations have the right to defend a lawsuit. Two things I want to talk about, and I'm presenting in the reverse order as set forth in our text. First, and this is section 112, except in small claims court, non-attorney employees of the corporation cannot represent it either in a lawsuit, prosecuting it, or defending it. A corporation must retain an attorney to file or defend a lawsuit. Simply put, if the lawsuit is not in small claims court, the corporation cannot represent itself. It must hire a lawyer. Second thing I want to point out, in order to have capacity, a corporation must be active. If it has been suspended, it loses capacity to sue or defend. A suspended corporation has no capacity and cannot participate in litigation. Here's how this works. Corporations are required to annually file documents with the state of California. If they fail to do so, or if the corporation dissolves, they are not considered active. A corporation that is not active can't defend itself, and a judgment obtained against a suspended corporation, it is possible to later to get the judgment amended to name the owners individually. As a paralegal, whenever a corporation is a party to litigation, always check the corporation's status to make sure it is active and not suspended. This can easily be done through the California Secretary of State's office. Example, your boss says, we've got a new client and they want to file a lawsuit for breach of contract as their customer did not pay for the product they sold. Prepare a lawsuit. But when your boss says your client is a corporation, unless your boss says don't, as a paralegal, you should always check to make sure the corporation is in good standing, or in other words, active in California. Here's how you do it. You go to www.sos.ca.gov, which is the California Secretary of State website. I've given you the link to this website in your lecture notes. You go to the business search function on the Secretary of State's screen, and what you see here is after a couple of clicks, you get to the results of a search which I did for a client of mine. Simple cash loans. You see it in the middle of the screen. Note at the red arrow under the column status, it is active. That means this corporation has the capacity to participate in litigation as a plaintiff or as a defendant in California by being an active corporation with the Secretary of State. Simple Cash Loans, Inc. has capacity, the authority to come to court as a plaintiff or as a defendant. Here's another example. I input into the Secretary of State website the name London Square. This is just one page of the results. These are all the London Square, or all the corporations that use the words London Square in their name. Note that on this page there are 8 entities listed, but only one, the second one, has capacity to participate in litigation. All of the others lack capacity because they are not active. These other corporations do not have the capacity to sue or to come to court to even defend a lawsuit. If it says dissolved, if it says suspended, they lack capacity. It must say active. So as a paralegal, when you are checking to see if a corporate entity has capacity to participate in litigation, you go onto the California Secretary of State website, you look up the corporation, you look in the status column, and make sure it says active. If it does not say active, you've got to have a discussion with your supervising attorney. Next category, partnerships and unincorporated associations, and we're at section 122 in our book. Partnerships and other unincorporated associations can have capacity to sue or be sued. Businesses can be operated by individuals, and I'm sure you know businesses can be operated as corporations. And we've just discussed 2 factors which pertain to corporations. With a few minor exceptions, these factors I just mentioned for corporations to be active also apply to certain partnerships and business entities, such as limited liability companies, often referred to as LPs, limited liability companies, often referred to as LLCs, nonprofit corporations, and unincorporated associations, usually smaller churches and clubs. These entities are also required to be registered with the California Secretary of State. And just like I showed you with corporations, you can check to see if these entities are listed as active. The fourth category in our book is at 126, estates. I want to give you two examples in regard to capacity for estates and for trusts. First, someone dies. For that decedent's assets to go to that person's heirs, a probate must be opened. That means an executor or an administrator is appointed under the court's supervision. If that estate needs to file a lawsuit or defend a lawsuit, in other words, someone owed money to the decedent before the decedent died, now a lawsuit needs to be filed to go get the money, the estate can have a representative be appointed by the court to have capacity to move forward with the litigation. Second example, while a person is alive, the person places his or her assets in a trust. A trust is a written document with instructions as to what happens to that property on the death of the person. If this is done properly, upon death, the assets go as instructed without the need for a probate or court oversight. But what happens while the person is still alive and that there's a trust that owns assets or money is owed to the trust? How does the trust file a lawsuit? Because the trust doesn't have capacity, the trust will have a trustee, and the trustee is the one that has capacity. Now, like corporations, estates and trusts have no capacity to sue or defend a lawsuit. However, a probate estate has an executor or administrator, and a trust has a trustee. These people, the executor, the administrator, or the trustee, have the capacity to sue or defend a lawsuit for the benefit of the estate or the trust. Building contractors, our next category, starting at 131. In California, to do building or contracting work, such as plumbing, adding a room to a house, putting a new roof on a building, installing an electrical outlet, if the charge for this service or project is $500 or more, the contractor must be licensed by the California Contractors Board. An unlicensed contractor has no capacity to sue or to be in court to defend itself. In other words, hire an unlicensed contractor to do work on your house and then don't pay. There's nothing the contractor can do in court to collect if the job cost was $500 or more, so long as you point out to the judge, hey, this contractor was unlicensed. So as a paralegal, if your boss says, we got a new client, a building contractor who didn't get paid and wants to file a lawsuit, as a paralegal, you better check to make sure your client has the capacity to go to court. Here's how it's done. You go to the website, www.cslb.ca.gov, which is the California Contractors State License Board. This web address is also in your lecture notes. You go to the business search function. on the screen is the result of a search for Jones Construction. This is actually the first page of many with companies using the name Jones Construction. As you can see at the red arrow, other than the Jones Construction in Turlock, all the others listed on this page are not licensed as contractors. Only the Jones Construction located in Turlock has the capacity to file a lawsuit or to defend a lawsuit. Just like for corporations, limited liability companies, limited partnerships, we look for the word active. If not active, the entity or person lacks legal capacity. As you can see on this screen, every other one says expired other than Jones Construction and Turlock. Jones Construction has capacity, it says active, the others do not. Example, one may have standing, the right to seek relief. A builder adds a bedroom and a bath to a house and the homeowner fails to pay. That builder has standing. But if the builder did not have a valid contractor's license, the builder does not have the capacity, the authority to sue the homeowner. And if the unlicensed builder does shoddy work and the homeowner is already paid, the homeowner can sue the contractor for a refund and the contractor cannot come to court to defend the lawsuit. That is how the concepts of standing and capacity are intertwined. One can have standing to sue, but may not have the capacity to sue. Think back to the first example I gave you of the 17-year-old struck by a car. The 17-year-old has standing, personally aggrieved, but lacks the capacity to sue. We know how we address that problem, and that is with a guardian ad litem. And as for the last examples I gave you, unlicensed contractor does work and is not paid. The contractor has standing, personally aggrieved, he wasn't paid, but lacks the capacity to go to court to sue. And if the homeowner sues the contractor lacks the capacity or the authority to defend the lawsuit. There's more to this concept of standing and capacity, but we'll leave those details to the attorneys. Procedures for challenging a party's capacity, starting at section 137 in our book. We previously learned that if a plaintiff lacks standing, the defendant can challenge that at any time, even after the trial and a judgment has been rendered. But challenging capacity usually requires the challenge be made as soon as the lack of capacity is known by the other party. Failure to challenge can result in the waiving of the right to do so. So how does one challenge a person or entity's capacity to be in court? How does one say? What does one do to say, hey, that party lacks capacity, has no authority to be here? Two main ways. First is a demurrer. We're going to get to that in chapter 7. I know on your screen it says chapter 2, that's a typo, chapter 7. We'll get to that in the chapter called Attacking the Pleadings. But for now, as I previously mentioned, think of a demurrer this way. A party going to court very soon after the lawsuit is filed and saying to the judge, I should not be required to do anything because there is a major defect with the complaint. Just know this regarding a demurrer. If a party who is almost always the defendant or the cross-defendant prevails on a demurrer, that party walks away from the lawsuit. Second way to challenge. You can challenge capacity in the answer to the complaint. We're going to get to answers to the complaints in Chapter 6. But for now, note this. Someone files a lawsuit and serves the defendant. If the defendant wants to fight the complaint, the defendant usually files an answer to the complaint within 30 days of service. The answer is where you often find the objection to capacity. Now you may be thinking, why not file a demurrer and try to get the lawsuit tossed out of court right at the beginning? Because you may not discover the lack of capacity until after you file the answer. Let me give you an example. You hire a contractor to do work at your house. The contractor has a license number on his business card and on the contract. The work is performed, but it's poor quality, and you refuse to pay. So the contractor sues you. You hire an attorney. The attorney will prepare an answer to the complaint. And in the answer, the attorney is going to include something called an affirmative defense. We'll get to that in Chapter 6. The affirmative defense will say something like, and this is not in legalese, this is plain old English. This is not the way an attorney would write it, but it would mean the same thing. If the contractor had no license, he has no capacity to sue my client. Well, you say to your attorney, but he's licensed. And your attorney should say to you, you hired me, let me do my job. And you ought to say at that point, okay. Now, while waiting for your trial date, which will take probably about 2 years, discovery will be conducted. That is where each side can ask the other side questions, both orally and in writing, and the other side must respond. We're going to get to that when we get to Chapter 8. But in our example, assume in answering discovery, the contractor states that the license number, which the contractor showed you, actually belongs to his brother. Now, when you get to trial, the contractor will say, I did the work, I'm entitled to the money, judge, make the defendant, that's you, pay me. Your attorney is not even going to talk about the poor quality of the work. Your attorney will simply show the court proof that the contractor was not licensed at the time the work was performed, and the judge will throw the plaintiff's case out of court because the contractor lacked capacity. But assume your answer to the complaint didn't allege there was no license. Then the judge should say to your attorney and you, too late. You waived your right to object. When we get to the topic of answers to complaints, the subtopic we'll discuss will be affirmative defenses. We're done with standing and capacity. We'll continue with the next topics covered in Chapter 2 in the second lecture for the week.